All right. Well, Henshaw here again, your friendly local constitutional cook with another of my current events videos. And this one we're talking about changes in circumstances, especially with this COVID pandemic crap we've had to deal with for over a year now. And one of the big deals, and this is the new normal, we'll see how long it's going to stay that way. Because trust me, these quote unquote elected officials that we have no interest whatsoever in seeing us person to person if it's at all avoidable. And yet, wouldn't you know, we have the right, uncontested right, to petition, to instruct our representatives and what it is we want them to do. We have the right of redress of grievance and, in general, the right to be heard, and they don't want anything to do with it. One big reason for that, especially true in California, is that the assembly there in Sacramento has all of 80 members. 80. What do we have in California population wise? 40 million. Do the math. On the average, and Lord knows what it would be in LA or one of the bigger cities like that, San Francisco, on the average, one member of the assembly is going to have 500,000 constituents. How in the world are they possibly going to be able to respond to even a very small percentage of that in terms of being instructed and this, that, and the other and redress of grievance? It's not possible. And that's one big reason, by the way, that we do not have the Republican form of government guaranteed to states by Article 4, Section 4 of the Constitution for the United States. It's a hell of a lot better than that civil rights crap you're out there slinging around, Al Sharpton and Jesse Jackson. Do some real issues, why don't you? Get off the backs of your people. That said, for comparative purposes, look at Article 1, Section 2 of the Constitution of the United States, where it talks about ratio of representation and the maximum, and it's there where you can read it verbatim. The maximum is 30,000 inhabitants for one representative, and yet we have 500,000 to one in Sacramento. That's wrong for multiple reasons. I'll be doing a video on that, and I'll let you know when I'm going to do it. This is an important video as to why we need to get back to where we should be. And by the way, it's been 80 since the Constitution of 1879, what I call the bastardized version of the Constitution, hasn't changed at that time with the population being under a million. The racial representation was something on the order of 16 or 18,000. And that was difficult even in those times because no internet, no TV, no electronics. I get that. But still, at least that was somewhat manageable. But and it's in the Constitution of 1879. It says it maximum 80 and 40 in the Senate. So the senators have a constituency of 1 million per pop. My God, what kind of a government is it that we have here? The answer to that question quickly, I would just tell you, take a look to the far east there, over to China, the Soviet Union, and Pyongyang in North Korea, and you get a really good example, and it's much more similar than you would think. That's a video for another day, but trust me, it is. So what we're going to do now is I'm going to change out some of my documents, and those of you who have my package, you're going to get updated documents, and we want to file documents. Now, in some jurisdictions, in the quote-unquote state court, which isn't, but some of them now you can actually get in there and present documents to the clerk to be filed. And I started out doing that for a long time in California. I never had a problem. So if that's the situation, that's even better, because once the documents are filed, and do not let them stamp it received, stamp filed. That's officially before the court. The local dumbass has to answer it, and they're never going to do it. That wins the case. If they can't prove jurisdiction and venue, how the hell are they going to get in there, for example, in a traffic court and prove that you are a quote unquote person required to have a driver's license to drive on any of the highways in your quote unquote state? Now, just so you know, person quote unquote means the same thing it does in the non existent 14th War Amendment, and it means corporation there. So when you get pulled over by these law enforcement thugs these days, they're confusing you with Chase Bank, IBM, Microsoft, you name it. But clearly, we're not corporate entities. And to get to the legal definition of license, you're going to love this out of Black's Word Law Dictionary. Permission granted by competent authority to do an act that without such permission would be illegal, a trespass, or a tort. What the hell is this? And this is the change we had, by the way, and it's discussed in my brief on the 14th Amendment that you'll get by ordering my materials. By the way, send me an email, uwinandcourt@gmail.com. I'll get you information on all that. Because what happened with that 14th Amendment and what was planned to happen, but nobody who ratified the amendment knew, and it wouldn't have mattered anyway, that's something else you'll learn, was the intent was to make citizens out of artificial corporate entities, or what I call birthright citizens. That's all that is. But they didn't tell anybody. Where's the consent of the governor there? So they can't prove it. And then license, when they say it's a privilege, that's true because all corporations have are privileges. We have the right to travel, the unlimited power to contract, the right to a judicial court, the right to trial by jury, and you won't see that anywhere in any of these what fraudulently purport to be state courts of common law general jurisdiction from coast to coast. Ain't there. Ain't. Even the 904 have ruled that there's no right to trial by jury in any criminal misdemeanor case. Blanton v. Nevada, 489 U.S. 538, I believe, is the citation on that. And they've intimated in other decisions there may not be a right like that even in a felony case. They haven't formally decided yet, but don't be surprised if that happens. I mean, that's how bad this is. And yet the Seventh Amendment says, by example, which doesn't apply to the states, but if it did, that we have a right to trial by jury in any civil case where the amount in controversy is over $20. What the hell is this? But that's what you get into here. So we're going to start to put a lot of pressure on the clerks. With federal ones, they're going to have to probably be by mail. And I can't even get into any federal court, by the way, since they don't recognize my state citizenship. And I do not have any ID issued by what I call the de facto national socialist government that they say is required to get into their quote unquote courts. So we're going to put a lot of pressure on the clerk and tell them in no uncertain terms, you don't file it. And they're going to get a lot of authority. You'll see it from the Supreme Court and other places that we have a right to be there. And we are not limited by any forms promulgated by the goddamn California Judicial Council. There's no filing fees we have to pay, and there's very good reasons for that, as you'll learn. And we're telling the clerks in no uncertain terms, if you refuse to file the documents, you're the one that's going to be charged with treason. At the same time, they'll be getting our letter to the presiding judge of their court explaining all this in further detail, and hopefully get them to do their job because they have the sworn duty to be bound by this Constitution and the laws enacted in pursuance thereof. Clerks are somewhat more questionable, especially in a federal court. Now, the good news for us in a state, and don't we wish we were in one, the county clerks here in California with the original Constitution are designated as ex officio clerks of the district court, not the federal district court, the California district court, contemporaneously recognized as a constitutional common law court. If we get into there, the ball game is over. And corporations can't come in there without our permission. Attorneys can't do it without our permission. And I ain't giving it to them. That's a judicial court. We have a right to it. And that's a foreign jurisdiction to them, just like their jurisdiction is alien to us. Or as the framers of the Constitution said in the Declaration of Independence, foreign to our Constitution and unacknowledged by our laws. That's the way it's supposed to work. And the clerk is going to be the one we put pressure on because they're the one that's going to be facing the charges. And we're going to tell them, it's going to be you. If you want to quote unquote rat out whoever told you to do it, namely the presiding judge, probably, or it may go as high as the Attorney General, now Merrick Garland, or even as high as the office of the president, which has been vacant for a long time. We'll go into that on another video. We want to know who told them and why, and you're going to get a document called Indemnification and Hold Harmless. You'll learn a lot more about that when you get my materials. Send me an email, uwinandcourt@gmail.com, and we're going to, in effect, say fines. We're going to require us to use the forms. Then you're going to guarantee the Supreme Court won't hold that against us. And if we're going to require us to pay filing fees or whatever in Federal Reserve notes, undefined dollars. They're going to indemnify and hold harmless on that ground too if we can't get our case to the U.S. Supreme Court. And there is powerful authority for that. You're going to absolutely love it. So this is what we're going to start doing, is putting a lot more pressure on them, and we're going to get this message across to a lot of different people and a lot of different levels in government, and saying it's about time you start doing your damn job here, especially the U.S. Supreme Court. 150 years, you know better than this. Because if we get it filed and get it squarely before them, they've said it themselves. They have a right to present our case to the court of the nation. That's how good it is. With that kind of leverage, that's why they don't go to trial against you and dismiss charges in the interest of just us in order to get out from under and minimize their losses. That's what's really going on behind the scenes, because they realize not only do we know the law, they can't admit on the record that they don't. That's not exactly what you call a job qualification to be a black robed bastard now, is it? So it's just how good it is. This is one reason, by the way, at the age of 72, my life is still ahead of me. I've got 8 or 10 years to give in family genes and history, maybe more than that, to make as much trouble as I can and to teach you how to do it out there, and to teach you how to teach your kids and your posterity how to do it and get out from under here. More of us to start doing that, and the quicker we do it, and across the board, by the way, Americans, Africans, Asians, and knock off all this divide and conquer BS they've been doing for at least 150 years with all this civil rights crap. Wasn't designed to work, isn't going to work, except the rare case they have to make it look good, like a Rodney King. I mean, it does happen, but not so as you notice. And especially in the last 4 or 5 years with all the murders by cop we've been seeing out there. So that said, we can change it. We're the only nation ever created where that can still be done. If that Constitution remains there as the supreme law of the land, we can't lose. If it doesn't, it'd be nice if the Supreme Court would tell us that openly and notoriously and be done with it. Then we can take matters into our own hands and do what it is we have to do. That said, send me an email, youwinnincourt@gmail.com. I'll get right back to you with the information I have. Meantime, subscribe, like the videos, tell your friends, get the word out. Thank you.